General principles and considerations. Article 1156. An obligation is a juridical necessity to give, to do, or not to do. Juridical necessity, juridical tie, connotes that in case of noncompliance, there will be legal sanctions. An obligation is nothing more than the duty of a person, obliger, to satisfy a specific demandable claim of another person, obligee, which, if breached, is enforceable in court. A contract necessarily gives rise to an obligation, but an obligation does not always need to have a contract. Kinds of obligations. Civil obligation. Natural obligations. Moral obligation. Civil obligation, that defined in Article 1156. An obligation, if not fulfilled when it becomes due and demandable, may be enforced in court through action. Based on law, the sanction is judicial. Example. On May 5, 2020. James borrowed $20,000 from Alan. They agreed that the payment will be on June 15, 2020. During the agreement, James executed a promissory note. If James cannot pay on the stated date, Alan may enforce payment by filing a court action within a period of 10 years from due date, specially on June 15, 2030. Natural obligation, defined in Article 1423, a special kind of obligation which cannot be enforced in court but which authorizes the retention of the voluntary payment or performance made by the debtor, based on equity and natural law, i.e. when there is prescription of duty to pay. Still, the obliger paid his dues to the obligee, the obliger cannot recover his payment. Even there is prescription, the sanction is the law, but only conscience had originally motivated the payment. Example. James obtained a loan of $60,000 from Alan. The debt, which is evidenced by a promissory note, is due on June 15, 2020. No action of payment was filed in court by Alan within 10 years from such date, hence, the debt prescribed. However, James, knowing that his debt prescribed, voluntarily paid Alan. James cannot recover what he had voluntarily paid, although payment was no longer required. In equity and moral justice, he still owed Alan the amount of $60,000. Moral obligation. The sanction is conscience or morality, or the law of the Church. It is almost similar to the natural obligation. In case there is non-performance of the obligations, you cannot go to court and file an action for a specific performance. Example of moral obligation. In Catholic, our moral obligations to hear Mass every Sunday, but we know that some of us do not religiously hear Mass every Sunday. And you have not heard to a priest, files an action or imposing sanctions for a specific performance because, although it is our obligations, it is simply a moral obligation. Elements of obligation. Active subject. Passive subject. Prestation. Efficient cause or juridical tie. Active subject, creditor or the obligee, the person who is demanding the performance of the obligation. Passive subject, debtor or the obliger, the one bound to perform the prestation or to fulfill the obligation or duty. Prestation, to give, to do, or not to do. Object, subject matter of the obligation, conduct required to be observed by the debtor. Efficient cause, the juridical tie which binds the parties to the obligation, source of the obligation. Example. Mr. James promises that he will pay his debt to Mr. Allen. Answers. The active subject for these situation is Mr. Allen, while Mr. James is the passive subject for the reason that he the debtor or the obliger. An efficient cause or the juridical tie for this situation is the promise of Mr. James that he will pay his debt, while prestation is the giving of the payment for his debt. That would be all. Thank you.